Welcome to this edition of Elder Care Answers. Elder Care Answers provides valuable information for senior citizens and those who love them, so we can all be more informed consumers.
Hello and welcome to Elder Care Answers, a show dedicated to finding the answers to our elder care and estate planning questions. I'm your host, Ellis Cannon, and joining me is Doreen Seaman of Seaman Law Offices. Doreen is licensed to practice law in Pennsylvania and West Virginia, where she focuses her practice exclusively in elder law and estate planning. Welcome aboard, Doreen.
Thank you. It's great to be here today.
Let me start off by asking you about what elder law means, and for that matter, what estate planning means, and the differences between the two.
So estate planning is planning for what happens after a person passes away to their assets, maybe guardians of minor children. Elder law focuses more on what happens while the person's living. What kind of decisions do they want to have made? Do they want to protect assets? And again, who would care for minor children if that was the case?
I got you. All right, so most people understand estate planning involves things like drafting wills, powers of attorney, trusts, and so forth. But what else should we understand?
And those are very important documents. Everybody should have at least a power of attorney and a last will and testament. But what's in those documents is the key to how we protect not only ourselves, but those that we love.
All right, so I already asked you about what is elder law, but what types of questions, decisions, and issues are within that?
So for elder law, we need to think about what happens if the person creating the plan becomes incapacitated or has a long-term illness. What do they want to happen in regard to who will make decisions and what the priority of those decisions should be? You know, do they want to stay at home? Do they want to protect their assets in case they need long-term care? And then also what they want to happen to those assets as they progress through their elder journey and potentially pass away someday.
All right, well, that's excellent, and we're going to be detailing those today. Let's talk about Pennsylvania and West Virginia. You serve residents in both. Maybe you could talk about how that logistically works. One area that you obviously spent a lot of time in is developing the plan that you just discussed. That's totally different than litigation, is it not?
It is. So at my office, we do not litigate, but we do like to work with families to make sure that they don't end up in litigation
right.
and that their goals are met. So I haven't met anybody yet whose goal was to litigate, right?
Right.
So our original office was in West Virginia, and I've lived half my life in West Virginia, half my life in Pennsylvania, but our office in West Virginia is in Morgantown, which is very close to the state line. So what we've seen is so often people live in one state or the other, but then they end up in the opposite state because of family or jobs or maybe care issues. So oftentimes I would have to refer my clients back to an attorney in Pennsylvania because they left the state of West Virginia. So the natural transition, since I have such long ties to both states, was to open a Pennsylvania office so that I could serve my clients no matter which state.
I may remember that in litigation, but that's another story. Let's talk about veterans. As a VA accredited attorney, can you explain to us about what that means and why it is so important?
It's very important because if you're going to help a veteran who's having an issue with compensation, pension, benefits, you have to be accredited. So if you're an attorney, you would be a VA accredited attorney. If you're a non-attorney, you'd be a VA agent.
One thing we learned in the pandemic was the value of working virtually. And I suspect in your field that's also very important, particularly with veterans all over the country.
Right, because as we said, I'm licensed in West Virginia and Pennsylvania for estate planning and elder law, but as a VA accredited attorney, I can help a veteran anywhere in the country.
All right, let me play the hypothetical for just a moment. If there's a viewer out there that thinks that they were wrongly denied disability comp, or they want to apply for the aid and attendance pension, can you help them?
Yes, I can.
How so?
Well, first we would want to gather some information to find out what's going on. Sometimes people come and they just want the answer, but of course that's based on a lot of questions, right? But we would review their case and see what was going on and give them our opinion, and then we could proceed forward with the VA.
All right. Let's move on to the high cost of care, as we're all well aware, and we can drill down on that. You mentioned elder law includes figuring out what kind of care you want, how to pay for it. These numbers are shocking when you take a look at it.
Yes, they are.
I mean, you look at the monthly average cost, I think it's about $10,000 a month, roughly, give or take, when it comes to skilled nursing care alone.
Right, and people are always surprised. And the ones that know, usually when they come to my office and I say, what brings you here today? What are your goals? What can we accomplish? They say, I don't want to go broke in a nursing home, or I don't want the nursing home to take my house. So it is shocking.
It's a fear. It's a real fear, and I think that fear is compounded when you take a look at, for instance, I think it was 2019, the Government Accountability Office estimated that only about half, maybe 48% of the average American over 55 years old had any retirement savings.
Yeah.
I mean, so now you're looking at what you just characterized and not having retirement savings. So how do you manage your way through that?
Well, you have to plan ahead. And, you know, it might be insurance, it might be preparing for Medicaid, but planning ahead is the best way to get to where you need to be, right?
Right, because, I mean, I'm not good at math, but 10,000 times 12, that's 120 grand a year.
It doesn't take long to go broke.
It really doesn't. So let's talk about ways to pay for nursing home care. Those are shocking numbers to a lot of people. What do we think about how Medicare fits into all of this?
A lot of people mistakenly think Medicare or their supplemental Medicare policy is going to cover this, and it unfortunately does not. Now, if the conditions are right, you could get up to 100 days of coverage between your Medicare and your supplemental Medicare policy. After that, it's private pay. So it's either coming out of your piggy bank, or you're maybe have long-term care insurance and you get a reimbursement from your long-term care insurance for paying for that care. Then once you're broke, then you can apply for Medicaid.
Boy, that's quite the trigger to hear when you're broke. But you also said if the conditions are right, you get the 100 days. And, you know, honestly, that's not the longest period of time. And so there's obviously a condition has to be met there. But you also mentioned long-term insurance products. I've heard a lot about them. Mm-hmm. What are they?
So it's insurance you buy when you're young enough and healthy enough and you can afford it, for them to reimburse you for expenses on care. And usually there's about a 100-day elimination period on that. And that's because they know Medicare will cover that first 3 months or so. And, you know, but I just see a lot of people that either they hate insurance or they can't afford it, or by the time that reality sets in, the premiums are just too expensive because of their age or their health.
Yeah, it's a great point. All right, let's move on to what count as assets, and for that matter, talk about irrevocable trust. And when you said broke, what exactly does that mean, and what assets are counted or not counted towards somebody's application for Medicare?
So trying to be a little bit general, because West Virginia and Pennsylvania aren't exactly the same, but a home is exempt, one vehicle is exempt. In West Virginia, about $2,000 is exempt, and in Pennsylvania, it's usually either $2,400 or $8,000. So not much.
Okay. How important then is gifting to avoid losing assets?
Well, you can use gifting to avoid losing assets, but you really need to be careful about how you gift, because there are a lot of consequences between the lack of control and different kinds of taxes.
All right. So, in fact, when we think about that, that takes us to this 5-year look back. And what does that phrase even mean, knowing it's a loaded question?
Yes. Okay. So, let's say I have a stroke today. I can't give all my money to my kids and then head over to the local nursing home and say, hey, I'm broke, I need Medicaid. I have to have the foresight to plan ahead at least 5 years. The state Medicaid system will look back to see what gifting I've done over the past 5 years. And if I've done that, I'm not in trouble, but I'm going to have a period of time, a period of ineligibility, where I don't qualify till I've kind of worked that gift off.
Mm-hmm. Okay. Yeah, and that's very important, and obviously we'll continue to roll through that today and in future shows as well. More back to the irrevocability of trusts, and how do they work, and how are they useful in estate planning?
So if you and I were talking maybe 20 years ago, the estate tax laws were a lot different. And even a lot of regular folks ended up paying an estate tax through the federal tax system. Now in Pennsylvania, we do have an inheritance tax, but most people who come to me for an irrevocable trust now, they're not coming because of taxes. They're coming to protect their assets from the nursing home expense.
All right, well, that's exactly what I thought. As I look at this, though, if that's the case, why doesn't everybody do it?
Well, some people don't think they're ever going to get sick. They say they would never let that happen, that you know, nobody in their family's gotten sick, or they just refuse to accept that possibility. But if we think about our grandparents' age, you know, people didn't tend to go to nursing homes. They weren't sick or incapacitated for many, many months and years often. And things have changed quite a bit. So it is much higher likelihood now that between a spouse and the two spouses, somebody is going to potentially need care. So for most people, it's a conversation worth having, and make an educated decision on what you want to do, knowing the consequences.
Just look at the rise in claims of disability alone, and depending on the complications
Yeah, that's a great point.
Yeah, that's something to keep in mind. So when generally do people do themselves the best service by creating such a trust?
So I usually see people in their 60s and older doing the trust. The oldest person I had do one was 98, and she did it because there's also a tie-in to some veteran benefits, and she did it to get the veteran's pension, and she managed to get it for about 6 or 7 years. She lived about 105 or 106. So, but usually people are in their 60s or older.
Yeah, I'm really glad we're having the conversation, because that whole Veterans Administration option is something that folks can consider as well in this planning. If I created this type of trust, can I put my home in it, for instance? Is that the type of thing that's even possible?
Yes, so you can put most assets in it. The one type of asset you don't put in it are qualified accounts. So that's going to be IRAs, 401ks, 403bs, all those letter and number type accounts that are really confusing. We can't put those in the trust. But what I see people put in most often would be home, farm, or extra property, the hunting cabin, life insurance, and different types of investment accounts. So some people are very aggressive and they put almost everything in it. And then other people say, well, if I can just protect my house, if I spend all my money, I'm okay, but I just need to protect this house. So it's that person's decision what they want to fund it with.
But that's a case-by-case thing. And you have the lists, you're the expert, you roll through those, and you can tailor depending on what is the best plan for them.
Exactly. And everybody has a different amount of money or assets they want to protect. And what I see most often isn't a remorse about what they put in the trust. It's that they come to me later and say, I wish I would have put more in the trust. Can I do that now?
All right, yeah, for sure. So let me ask you about that. I mean, again, this makes sense to protect assets, but what about taxes?
Yeah, so we have lots of different types of taxes to think about, right? So in regard to trusts, the way that the taxation usually works with these trusts, and there are nuances that would be case specific, but generally for my typical client, the person creating the trust continues to pay the taxes on the income from the trust. So let's say I put my home and $100,000 in my trust. It doesn't mean that I have $100,000 of income every year. It's only the income off of that $100,000. So just like I pay the tax on that today, I continue to pay it once that money's in the trust. But for highly appreciated assets, we have to think about capital gains tax. And so capital gains tax, at the federal level, the highest amount is about 20%. And then there's Affordable Care Act surcharge of 3.8%. And then we add the state tax. So we want to avoid capital gains tax. So receiving the asset from the trust when the person who created it died is a very good outcome for that.
Right, yeah, this is very important. So the advantage of gifting to this type of trust rather than an individual is pretty clear. It does start this 5-year look back, and also it's favorable when it comes to a tax outcome. Let's continue that conversation. We said we'd drill down. Who owns these assets?
Right, so the trust does. So usually my clients who create this type of trust use a trusted family member as the trustee. So for trustee, let's just think of a manager, okay? They don't own it, they're just managing it, okay? So most of my clients choose trusted child or children, it can be more than one person. So I would gift my home to the trust, think of a box, put my house in my box, shut the box, put a lock on it, hand my favorite child that I trust the key, okay? That child would be the trustee.
Right.
So the child doesn't own it, I don't own it, the trust doesn't. And trusts don't get divorced, they don't go bankrupt, they don't get sued, and they don't have a lot of liability like sometimes people do.
But locked means locked.
Well, it's not stuck in there, but if I want to access that, I have to rely on my child acting in my best interest,
Right.
the
There's
trustee.
Exceptions and exemptions and all those types of things. Do you find that the manager metaphor works? Because I think it does for me. I mean, you know, the manager is tending to what that person as a trustee is responsible for, but the ownership is for the people upstairs who own the company.
Right, right.
And that was very helpful. But do you find that sometimes people struggle with giving over control?
Most of them don't. Now, if they do, let's say you don't have a child that you trust to hold your key, to be the trustee or manager, then you shouldn't do the box. You shouldn't do the irrevocable trust. I certainly don't want a client to create a trust, move their assets that mean the most to them to the trust, and then not be able to sleep at night because they've lost control. So if we don't have somebody we trust to that level, or maybe that person's just a control freak, right? We all have our things that bother us. Then a trust, you know, then we just see what happens. You know, if they end up in a nursing home and they haven't planned ahead, we'll deal with it at the time. Most of my clients, though, once they fully understand how the trust works and they get their questions answered, they feel pretty comfortable with it.
Yeah, it gives them long-term peace. I would just suggest that it's important for folks that are coming to you to just be honest with themselves. I mean, this, like you just said, I mean, if you're in such control that you can't give things up, it's very important for them to be honest with that.
I can usually tell by their questions what's eating away, you know, because maybe they're worried not so much about their child, but maybe their spouse. And then I get the, you know, well, can she do what she wants with it? Or, you know, so usually, but being honest, it just helps us to get to where they want to be.
Right.
And we certainly don't want anybody to do a plan they're not comfortable with.
So as attorneys, we know that when you ask question A, you may be really interested in B over here. And
yes, exactly.
Your gut will tell you that. Hey, let me ask you then, it's a trade-off. So you retain under the scenario we're talking about direct control of assets that would otherwise be exposed to high cost of nursing home care versus retaining lesser control over the assets, and that makes you feel good, but on the other hand, most of your clients who have a trusted family member are, I suspect, comfortable knowing that they've given away that control and protect themselves.
Yes, that's the trade-off, the control and the protection, and you have to balance it.
Right. All right, so let's move on, and I want to talk about planning ahead, and that is going to include even younger folks. So let's talk about that for today. I mean, we've already talked about protecting assets. That's central to, of course, everything in taxes when we start talking about estate planning and estate law. How old does a person have to be? I mean, is 18 too young? Is 90 too old? Give us some sense of where age fits in here.
And that's kind of where I feel elder law is a bit of a misnomer, because the youngest client I had who lost capacity and we were trying to intercede and help her was 22 years old. She was in a car accident, she was hit by a drunk driver, and she was incapacitated, and the family came to us to figure out what to do next.
Well, again, I'm not so sure then there's a cutoff of any particular age.
No, as long as you have capacity, you need to make sure your documents are up to date and accomplishing your goals. So we recommend people come in for a little checkup or check-in every 2 to 5 years, depending on what's going on in their life.
Right, right. And so when we start talking about some of the basics, the last will and testament, for instance, that's important product. Again, it's a document that does what it does. But on the other hand, you have to consider, as we talked about now, just moments ago and previously, the concept of incapacity. I mean, it just has to be part of that conversation. No one's Teflon. And
Right.
sooner or later, there could be a moment, right?
Right. So a scenario I commonly see is where you have a couple, maybe one is doing a little better mentally, one a little bit better physically. They're managing to live at home safely together, but then the so-called healthy spouse passes away unexpectedly, and then the surviving spouse isn't well enough to live at home, and then he heads to the nursing home. There's a planning opportunity if we have the right provisions in the first spouse's will to protect a good portion of the estate so that it can be used for the benefit of that person heading for the nursing home, but we can shelter a little bit. So having those provisions in our wills and powers of attorney, regardless of our age, because it doesn't have to be an age-related illness. Maybe a younger couple has a car accident and they're both severely injured.
Okay, so let me talk about powers of attorney just for a moment. Again, I think the best way this works is if people are clear-headed and you're able to coordinate all this, and we'll talk about that too. But what happens if there is a sudden illness and you have an acute moment? Is it too late to have a power created, and is it more costly? Give us some scenario. What happens when that acute moment happens?
So if something like that happens, but they have enough capacity to understand what they're signing and the impact of that, we can still make it happen. So some people think I mean physically. You don't actually have to physically be able to sign it. It can be notarized, and the notary can say, this person directed me to sign it on their behalf. What we're talking about is up here. Do they understand what they're doing? If they don't, then we've lost that opportunity, and then we have to go through a court process called a conservatorship.
Right, and I was about to characterize it as a court process. So right off the bat, now we're talking about something that's outside the scope of potentially what we could control, and now we have the court, and the conservatorship is a process for sure. But I'm feeling that there's going to be stress on top of stress.
Right.
That's how I see it.
Well, the court's going to do the best that they can, but there are certain protections for the person. So it doesn't usually happen overnight. It's going to take weeks, and sometimes we see it take months, even when nobody's fighting, because of the process. But then the judge that's making these decisions, they're making the best decision they can based off the information presented to them. And so if you have multiple people interested in being your conservator, it doesn't mean the person you would have picked is the person appointed. So, we might have on the surface a few good kids, but you might think, well, but that person would not be good with the money, right? So when you don't do a power of attorney, you're choosing to give up that control. So a lot of people don't want to do their estate planning documents because they feel like doing so makes them give up control, but it's the exact opposite. You're giving those decision-making powers to either a court or the default state laws that are on the books.
Right. And so when you're balancing emotion and analytical aspects of it, again, it's important to consider all of these different things. But the payoff be, if you do it early, you can choose your decision makers and, again, help that process. Let's talk a little bit about general estate planning. And that would mean how do we know a client, and more specifically, what a client needs?
Yeah.
How do you work your way or even start that process?
It is a process at our office. So it all starts with we have them fill out an intake form before they come, and hopefully they turn it in time for us to review before they come in. And then we start with, what are your goals? Because I might look at somebody's intake information and think the conversation's going to go one way, but sometimes the conversation and their goals take us completely a different way. So just because I'm an experienced attorney doesn't mean I know what you want in your will. I might have a good idea, an educated opinion, but it comes down to a conversation, and our intake forms targeted to bring up some subjects so that I know what I need to ask the follow-up questions for.
Oh yeah, this is important. I mean, again, they need to be accurate, they need to be honest so that you can begin to form that plan that is in effect customized for them and their circumstance. And I'm glad you've hit that a couple different times. It's certainly not downloading a will off the internet. It's a totally different process altogether.
It is. You know, we spend a lot of time helping people fix those after it's trying to get a better outcome from that, because those aren't designed to really delve into the elder law or disability type of issues, but it's also only asking you some basic questions, and then not the, well, then what? Or the what if this, or have you thought about that?
Right.
And so they're not designed for that purpose.
No, and what I am hearing is a lot of coordination, as I said earlier, and to your point, not all documents are the same. The particular, it's not a question of just a document or a title, but the particular wording, and that's where your expertise and the needs of your clients are important to come together. Let's talk a little bit about really relying on the right people. Obviously, you're a right person, and people who practice this field, as opposed to somebody that, you know, heard something and maybe read something, or somebody mentioned something at a restaurant. I mean, this is stuff you've got to go get expert advice on.
Right. I see a lot of people make mistakes based off of well-meaning advice from family, friends, neighbors. They might say, well, you can give $16,000 a year and the IRS doesn't care. Well, I can assure you Medicaid does care. So, or put your house in your children's name, but not understanding the family dynamics and the capital gains tax issues that go along with that. So you're right. It needs to be not only by a professional, but by somebody who works in this area of law.
Right. Yeah, well, again, not all lawyers are the same either.
No, and you don't want to come to me if you slip on a banana peel to sue the grocery store.
Right.
I'm not the girl.
Well, I was the guy who defended the store, so I understand the difference. So I guess we've covered a lot today. One of the real big takeaways is this can be confusing. I think you explained in a way that folks can certainly understand it, but how do they reach out to you in order to delve into this more specifically to their situation, the benefits, the costs, and so forth?
Right. So the best way to start the process with us is to either call the office or go to the website. We have a couple ways to contact us there. We have an online chat with a real person on the other end, and they can get you started. Or we have a button there where you can make an appointment, and you can make an appointment with a client intake specialist. So if you're not sure we're the right law firm for you, or we can help you with your issue, you can click on that button. You can set up a 15-minute appointment with our client intake specialist. She'll talk to you, see if we're a good fit, and if so, she'll make an appointment with one of the attorneys.
There you have it. Whether you need to create an estate plan or just update your outdated estate plan, that's a big thing. Start preparing for your future by contacting Doreen's office directly. You can also visit their website at SeamanLawOffices.com to request an appointment, to watch more of our television shows, or to find other resources to help with your estate plan. Be sure to listen to their podcast as well, and follow Seaman Law on Facebook, LinkedIn, and Instagram. Thank you so much for joining us today. We'll look forward to seeing you next time on Elder Care Answers.